they're going backwards. They just...
Yo, what's up, stream? We're about to, I want to watch the trial, so we'll, find that real quick. Probably just watch, like, a person that's watching it right now. Let's watch Asmongold. I'm kind of curious for it.
Right, it's included in their instruction, and that is basically the full extent of our proposed instruction, and we believe it should be limited to that.
That would make sense.
Lakova is a case that they've repeatedly cited in support of this republication issue, and that's a case where there was a defamatory New York Times article that was hyperlinked in a more recent New York Times article, and the court said that that's not directed at a new audience. It's the same party tweeting to the same audience, so there's no republication, and
because
that's not the case where Misheard has retweeted a Washington Post article, so that Ms. Heard's audience on Twitter is different than the Washington Post. And
but if she just retweeted a hyperlink, that's different. But in this context, and that's why I took the motion to strike under advisement.
Yeah, she said
once I got it, there was more content to it, and that's why I'm putting it in the jury instruction, because it is accurate that a hyperlink alone is not enough to reach a new audience. But I'm willing to.
Yeah.
There it is.
Would also add to it, though, is after you must determine whether any content that was added constitutes republication, and let's see, I would say then you must determine whether any added content republished the op-ed to a new audience. I could say it that way. Or I could say, but adding content to a linked article may constitute republication. You must determine whether any added content was intended to reach a new audience. If you find it was intended to reach a new audience, it constitutes a republication. I could say it in that term. Add that to the end of that paragraph.
I think that's fine if that's the court's inclination.
Do you have any objection to that?
Okay.
Nope.
I'm thinking. Sorry, I'm
slow.
Yeah,
she linked it in her original tweet.
Okay.
She did.
Let's see.
Yes, she did. And we saw it ourselves.
Incorporate into it. Okay, so merely linking to an article does not amount to republication, but adding content to a linked article may constitute republication.
Yeah.
You must determine whether any added content was intended to reach a new audience.
It was.
If you find it was intended to reach a new audience, it constitutes a republication.
Then it's a republication. 100%.
I think we would prefer just to say just that first sentence. Merely linking to an article does not amount to republication, but adding content to a linked article may establish republication, period.
Well, that's what you already had.
No, because we had you must determine whether any added content that was added constitutes a republication. I think it'd be better to just delete the last two sentences than to add the sentence at the end.
Your Honor, I just want to note, I don't think that adding content is a requirement for republication. I mean, we've found a number of cases that when somebody repeats a defamatory statement, that they're as liable as the original defamer.
We're not going back. We're not going backwards. So either it's his language or my language. What do you want?
I prefer the court's language.
All right, then we're going to put my court's language.
Okay. Yeah.
Okay.
Do you want us to do the revisions? Because if you do it, we may have to just get one.
That's
more
still
time.
fine. I mean, it doesn't really. I don't think it really makes that big of a
Sandy, can you
difference.
do it?
Yeah.
I hate violate the rhetoric that they're having right now. That like
The only other thing
Johnny's probably not gonna win, but fuck Amber Heard. I hope she loses.
The second line? Okay. All right, we'll take care of that.
Okay.
She sucks.
Yeah, I think that any jury is going to see that and know exactly what it is.
This one right here.
Especially since apparently people said they're like younger people in general.
If they actually find Amber guilty and like something happens, you know, I'll believe in the justice system again.
Yeah, they'll get it.
All right, takes care of that one. Next
Probably
one
at least.
is, I think, instruction FF.
Final Fantasy. Oh my god.
Defamatory meaning. Consider the publication as a whole. And we have dueling answers here. The defendant just has op-ed in it.
Yeah.
The plaintiff just has it as plain, which, I mean, it does say that it means you may not seize any word, phrase, or image. So it would appear that it could apply to both of them in that context.
Okay.
The problem, Your Honor, is that we believe that because the counterclaim statements that the jury will be presented with are redacted, so the statements are in isolation, that there's a risk that as they're phrasing it, the jury may read the phrase, "you must read the statements in context as a whole," to say, well, we can't do that, so therefore there's no liability. We think because it's impossible to read those statements in the context of the whole piece. And so that's number one.
Yeah.
Number two, the op-ed was all Amber's statements. So the whole
I
thing
understand
was
that.
her words. The counterclaim statements were Mr. Waldman's quotes in another article that we don't believe, well, that's not in evidence. So there's no point arguing about that other than you just have these one or two sentences from Mr. Waldman.
Yeah.
So we believe that the jury's going to be confused if we give their instruction and say we cannot read it as a whole, so therefore we can't, follow the jury instructions.
So basically,
Okay.
they're trying to stack the deck
I can see your
in their
point
side.
with that.
I
Yes,
get
sir.
that.
I don't think there's anything.
I think he's grasping at
there's-
straws,
there's
to be
a lot of
honest.
instructions here. I don't think there's anything that would indicate they can't find a liability if they're not able to take statements in their proper context, in the context of the entire article. Just thought it would be more appropriately phrased to be mutual, as
Yeah.
opposed to obviously applying only to one party.
Well, because yours says you must read the statements.
Who
which
are
is
these guys? These are
True, but you also.
these
can
must be
take
like
the
young
context-
guys.
In the context as a whole, but.
I've never seen
theirs,
them.
You can take the context of the op-ed as a whole, which is accurate. What I could do, if you want, I could keep the op-ed up top for their claim, and then for your claim, we can, in determining whether any of the statements attributed to Mr. Waldman are false and defamatory, you must read the statements. I could keep that in there as the second paragraph. That way they can't just pull out, because it's accurate law also, that they just can't pull out the word hoax and say, okay, this whole statement,
Agreed.
okay?
That's fine, thanks.
Oh, yeah, hold on.
That's fine in
Okay.
concept. I guess I would ask if Your Honor does that to add a clause saying disregarding any redactions on.
Hold on, let me.
Well, it says the statements themselves, statements, in theirs you must read the statements in context as a whole.
Right. So,
Move this over.
but I think, could we say in determining whether any of Mr. Waldman's statements or whatever are false and defamatory, you must read the text of those statements as
What's going on?
a whole. The text of those statements in context.
Amber
You have to know what they're
Turd.
saying and why they're
But it's
saying
kind
it.
of, you must read the statement in context as a whole.
She sure
You
is.
have to
Amber
You must
Turd.
read those statements in context. as
You
a
must
whole.
read those
Because I just don't
statements
want
in
them to think
context.
that it's impossible for them to.
Any problem with just putting those instead of the?
I don't think we have a problem with that.
Okay,
Your Honor.
in determining whether any of the statements attributed to Mr. Waldman are false and defamatory, you must read those statements in context as a whole. This means you may not seize on any one word, phrase, or image, or consider only one particular statement, phrase, or passage in isolation. Does that sound correct?
Yes.
All right, we'll add that as a second paragraph. Keep Sammy.
Yeah.
Okay. Well, I think those is previous tense and these is
All right, the next one I
future tense,
have
right? I'm not sure about that.
is the objections and assertions of privilege.
Yeah, I don't think it's a big deal.
32.
Oh, I'm sorry, it's Dep 32.
Okay.
You know, I think all these lawyers that are on Amber's side, they just need to lay down and take the
This is
L.
the one at the end. This is the new one.
It's
Yeah,
Do you have
it doesn't
objection?
change. It doesn't change it. Like it's obvious what's going on.
The objection, Your Honor, is that
Okay.
the objections made by counsel during the course of trial, we have no problem with something on that. But instructions, what they're trying to do is to direct the jury what inference to draw from Mr. Waldman's instructions not to answer.
Well,
And-
the only legal inference they can draw, you can't draw any inferences from that.
Exactly, and that's my point. Is
Well, and
that
that's what this says. You may not draw any inferences from the fact that objection was made.
yeah, but
Nah, I'm gonna go to the actual YouTube channel. What's this? Ooh, do I got some nope, just stupid shit. Alright. Let's go to YouTube and let's just go to the trial. I just don't want to look it up. Amber Heard, where you at, Amber Heard? There we are.
Fine. But you can't infer from that, oh, well, they're hiding something then, or it's attorney-client.
Understood. I mean, just like you can't infer when someone takes the fifth in a criminal case, I get that.
Right, which
but-
I would give an instruction for.
Of course, I know, I understand that, but I think that
You getting a little sassy, boy. Mr. Rottenberg, whatever your name is.
is entitled
Rottenborn.
to draw their own conclusions and not inferences,
Get a little
not entitled to
feisty.
infer anything from that. But I just think that
I
this
like you when
risks
when you're
confusing
feisty.
the jury and getting the jury to think. If they stand up in closing and say they haven't presented any evidence that Mr. Waldman was doing this, then that's using this instruction as a sword. If they get up there and say they haven't, do you understand what I'm saying? They haven't proven that Mr. Waldman was acting as his attorney. They haven't proven that Mr. Waldman was authorized to make the statements. Then they rely on this to hide behind that. And we're not allowed, and I'm not saying that we will, but I'm not going to say, you heard him instruct him not to answer, and you should infer that he was acting as his agent. I know I'm not going to say that, but if they're going to argue in closing the converse of that,
You're
then
mad.
that's prejudicial, and makes this
All
inappropriate.
right,
No,
yes,
you're
sir.
inappropriate.
This is just
You're
an
mad.
accurate statement of law. They chose to play about 30 minutes of Mr. Waldman being instructed not to answer. Without this instruction, that's prejudicial.
All right.
And it would also be prejudicial if they're allowed in closing to say
Hey, if
that
you're
we
in the
haven't
chat,
presented evidence of anything
give me a
about the
follow.
parameters of Mr. Waldman and Depp's
My
relationship.
whole goal in life is to have one follower that I can stream
doesn't
to.
follow from this instruction.
does.
This instruction is simply saying that the jury is not to draw any inferences from the objections and instructions inserted by counsel. They can consider the evidence. They can consider whether evidence was presented or not. The instructions and objections are irrelevant to that question.
No.
All right, I understand your objections, but it is an accurate phrasing of the law, and I want to make sure that the inferences aren't taken against an attorney-client privilege.
Yeah.
Okay. Can you deny it over our objection?
You got it. I mean, no, I can grant it over your objection.
Sorry.
Good, Freudian
I
slip.
meant grants. Yes, sorry. Can we get some direction for the arguments that they're allowed to make on closing on that, Your Honor? Because I don't think that that's appropriate for them to point to a lack of evidence when they didn't allow Mr. Waldman to testify.
All right.
Pointing out that instructions are not evidence is not the same. There's no connection here between these issues, Your Honor.
No, I'm not going to do that. So we're going to do Depp 32. I just need to clean up the top part of it. Okay. All right. Over objection. Be offered. All right, then I have instruction JJ, which is the model.
Right.
So why would I not give the model?
We believe you should. I think
Well,
I think the only looks like the only substantial difference is that rather than saying as it's written, it says clear and convincing evidence that Mr. Waldman's statements. It's confusing and misleading to say that if you have found by clear and convincing evidence that Mr. Waldman's statements were made by Mr. Depp, that we already have a principal agent instruction.
Right, if they find principal or agent, I mean, that would be the only basis for it.
Well, first of all, Your Honor, if liability is entirely vicarious, which I think is the position of the counterclaim plaintiff in this case, I don't think there's any evidence of direct liability. If liability is entirely vicarious, then I don't think there's a basis for a punitive damages instruction at all against Mr. Depp, because vicarious liability generally doesn't result in punitive damages as to the principal. Punitive damages are only applied where the person against which punitive damages are being assessed actually engaged in conduct that was wrongful, and that's not the way they've pled and sought to prove their case. I think that's the first.
So they're correct, okay?
Yeah.
They're saying you're not entitled to a punitive damages instruction.
Well, I disagree with that, and there's no case law that they've cited in here on that, and I think that's going backwards. That's an argument that we are, and I just think that Mr. Waldman's statements were made by Mr. Depp. I mean, I'd be okay with something that said that Mr. Waldman, while acting as an agent for Mr. Depp, made statements with knowledge. I'd be okay with that.
Is that okay?
I think we would maintain our objection on that. On the basis previously asserted, Your Honor, and then what's the other?
How much I want to bet the jury's already done deciding that Amber's guilty?
I'm sorry, could I have counsel's language again one more time?
Sure.
I
Yeah,
would,
if you
I
have
wouldn't
found by
need
clear
more
and
than,
convincing
5
evidence
minutes.
that Mr. Waldman, comma, while acting as an agent for Mr. Depp, comma, made the statements with knowledge that they were false or so recklessly, I think it's so reckless. There's a typo there, sorry. We'd be okay with that.
Yeah, I mean, we do maintain the same objection, Your Honor, that principal liability, and we do have case law for that
I'll
proposition.
overrule that objection. We'll go ahead and, can you type that up real quick for me?
Sure.
And get that to me? If you email it to Sammy, we can print it out.
Yep.
Okay, you're in charge of that one. Okay. All right. That's fine. I think that was it, correct, as far as?
I think it was, other than the verdict form.
Perfect. Let's go to the verdict form. We'll get this. Do you have the other ones for me yet, Sammy? Or still working on it?
Typing it out.
If you can print those out.
My man's whispering sweet nothings into my ear. Kind of like
All
it.
right, let me get the verdict form. All right, I think with the verdict form, it was just the first page. Am I correct with that?
You tell me.
In the punitive damages.
And the, well, the punitive damage, you didn't have a response, right? Do we have?
I think there was just there was a comment in what we got from them that we changed.
Okay. All right, well, in the, put it here. Oh, thank you. All right, I think it was in 1A, the statement was about Mr. Depp. I think the plaintiff wanted that out because we already have, the statement has a defamatory implication about Mr. Depp, and the defamatory implication was designed and intended by Ms. Hurd, which I think is,
If you look at the, I think it should track the finding instruction, which is jury instruction C on page
Okay.
4 of the jury instructions, and that's what the verdict form does.
okay, let me take a look. And that was C, okay,
So it is
Yeah.
going to count.
okay.
So the way it's been written tracks the
All
finding
right,
instruction.
tracks the finding instruction.
Yeah, we don't have a strong objection here, Your Honor. I thought it was maybe cumulative, but
It does match the finding instruction, which would be clear to the jury, so we'll keep that in.
that's fine.
And then the punitive,
And so
So
that
on
would
the
carry
last-
through to all of the,
oh, you withdrew all those?
We'll withdraw that, Your Honor. Their proposed language is fine.
All right, so the verdict forms as written are the verdict forms good to go, correct?
well, are
What
you,
was-
I'm sorry, did they withdraw the punitive damages? Okay, sorry.
So we're good with the verdict forms. What I have is the verdict forms, correct?
Your Honor, I think yes, but I do just want to make sure, and I understand we don't go back, but I just want to make sure that, for the record, we do maintain that the verdict form should state that the defamatory implication was false and not that the statement was false, because under the Pendleton case, that can, a facially true statement can still have a false defamatory implication.
And I think we had that on the record on Friday, but thanks
Yeah,
for
sure can.
putting it again, it's fine. All right, so verdict forms are good. So we'll keep the verdict forms. Did you print out the other? No, you can print it out, that's how, yeah. So which ones are we missing then? We're missing which jury instructions? You're working on 2 of them, right?
32, I have 32 in FF right now.
32 and FF, and you have 1 jury instruction for me, right?
Yes, they're
All right.
editing it right now. It's JJ.
Okay, JJ is coming in, and did you do the other one yet, or no? Here, I got that one. Here, could you guys do, Michelle, or could you, on Depp 32, could you take off disputed and send that to us too?
Yes.
Thank you. And that would just leave us, we'll get those 2 printed out, and then I'll tell you the order that I'm going to do them. While I'm doing that, I do have the laptop, if both sides would like to look at the jury evidence on these. They're going to, we'll stay up here at the bench, but all we did was we put 2 files on here. There's no password for it. As soon as you open up, it doesn't have any internet, and there's just 2 files. One's plaintiff, one's defendant. They just click on those 2, and then they can watch
That's
all
accurate.
the audio and the video, okay?
This is Amber's
So
Heard's
if you want to
face.
take a look and make sure, it's been downloaded to everything that we put on our website, which is all the evidence. We didn't receive any new evidence today for audio or video files, so that it's everything on there. But if you want to take a look and make sure that everything is there, you can do that. Also, all the tangible exhibits. Jamie will have, except we need to get
This is
those other
Amber Heard
ones.
when the,
So we can- oh, you have them?
jury comes back.
Yes, if I may approach, I have
Okay, sure.
1301.
Okay,
And then, Your Honor, I just would like some clarification.
sure.
Oh yeah.
I
Amber Heard
understand that
Amber Heard said that she was
Exhibit-
not smiling or
defendant's
laughing
exhibit
at all during the
712
trial.
and defendant's
Meanwhile, we
exhibit
got a whole picture right here of her smiling and
were
laughing.
initially moved into evidence in
I didn't know
redacted
that.
format.
Correct.
just so
Today,
funny.
we offered
just a
them and
liar.
put them
I
in
don't-
unredacted form, so that's the
712A and 712.
I don't know
And
how
then
you could be some lawyers and take the
713A.
case.
Yeah.
I believe,
So,
Your Honor,
they probably-
it should already
they probably
have
did
those
do
in
it, 'cause they-
unredacted form. I
like,
believe that's
they
how
just
they were
wanted attention
provided
and
to
Oh, they're
you
not
all
get their
binders
names out
down
there.
here?
I believe so. I will.
There's no way you took that case knowing
Yes,
that
so I believe those, you
that's-
should
that,
actually
like-
have those in unredacted form
right.
from
there's
defendants.
so many inconsistencies. There's no way they didn't see that she was late lying.
We have a few binders down here. Hold on.
Yes, I think they would be in the binders. That's correct.
712 and 713.
What is this?
All right, we'll take a look at those. Yes.
So I can give you a copy. I was gonna make a proffer for the ones that,
Do you want to go ahead and make a proffer now?
yeah, but it included 712 and 713.
Yeah.
I can give you copies of that.
This is basically what happened in the trial
That would make Jamie
today.
happy since she's down here digging through binders.
This is the whole trial today for
Okay,
Amber Heard.
perfect. All right, now we have those in evidence. Okay, so are we missing any more from over here? Or did you find out about the one that you thought was in evidence?
So, Your Honor, defendant, I believe, it's Plaintiff's Exhibit 120D. I believe actually Sammy and I had a number of back and forths about this exhibit. I believe that Defendant's Counsel provided a redacted
this
version
is
of that
killing me right
exhibit
now.
to the court, but based
I just
off
can't
of
imagine
our
just a big-
reading of the
just like-
transcript, that exhibit
Just a
was
big
not actually
poop on my
offered into
bed.
evidence.
I'd be so.
Okay,
I don't
so
know.
it's not in evidence then.
At that point, it's just time to go our separate ways.
I know it's just Sammy, last week,
You gotta take disputed off.
Oh yeah, another picture of her not laughing and smiling in the jury, in the courtroom. But she's never smiled or laughed and
All right, so I just want
was
to make sure
snarky
because it
inside
was
of
checked off on
the
somebody's
courtroom.
list that it was in evidence.
She never did that.
Sure. I don't know, but it's not.
These photos
We're
are
good.
the photos that I'm showing
And
you right
then
now. That's
I
Photoshop.
heard
There's no way.
Exhibits 711
This is
A
like-
and B. I'm
this
not
is
sure
what-
if that was an error.
This is what they're
712,
accusing
713.
Amber Heard of doing, which
So
she
we're
didn't
good.
do.
All right.
So Jamie,
Like,
are we
right?
missing anything else?
I don't know.
Sammy, did you print out the ones that they sent you to? The email, did you email Sammy the?
He's just double checking right now.
Oh, okay. We'll get that in a second. Let me just put these in the order.
Here, I got y'all real quick. If you haven't already, go sign this. Look it up. Look up remove Amber Heard from Aquaman 2. It's almost at 4.5 million. If you see this, go do it. Right there. Let you read it real quick. Remove Amber Heard from Aquaman 2.
Get that one without dispute on it.
Get her out of here. Do it like 5 times.
Okay, sure. Republication.
What else we got? Yo, this is Amber Heard's face when she took the shit on his bed. Oops. Yeah. This shit's killing me right now. I crap myself up. What else we got? What else we got? I can't be showing it on the screen because sometimes they be showing some 18 plus stuff up on the Twitter.
Just print out 2 copies so we can share them. The one that Sammy printed off on republication, I'm just going to give you a copy so make sure they're right, okay?
Yes, and you should receive in your email soon, FFJJ and 32.
Okay. So if you print those out too, Sammy? Let's print those out.
Oh yeah.
So you're sending FF also? Mm-hmm. Okay. Did you take the disputed off the top?
Yeah.
Thank you.
Let me see. Let me see. Let me see. Let me see. Let me see more memes of Amber Heard on her memes. There we are. Oh yeah. She said she didn't write the op-ed, but watch this, watch this, watch this.
I had no idea that the paparazzi would be at the courthouse on May 27th, 2016. You didn't expect a TMZ employee to show up to testify that TMZ had been alerted that you would be at the courthouse and knew exactly which side of your face to take a picture of, did you?
I know how many people will come out and say whatever for him. That's his power.
Yeah,
That's
everybody's
why I wrote
lying.
this op-ed. I was speaking to that phenomenon. How many people will come out in support of him and will fall to his power? He is a very powerful man, and people love currying favor with powerful men.
Currying
and I know
favor
that
and
firsthand. I've
risking
lived
jail
it.
time for committing perjury?
Excuse me. I didn't hear your question.
You didn't hear
Excuse
my
me,
question?
Ms. Vasquez. If you do mind,
Curry-
please just repeat the question. I didn't hear you.
Oh, look at her getting that
Favor and commit
attitude.
Perjury in this courtroom?
I have
For a
seen people
powerful
do this.
man?
I have seen people do this time and time again. That's why I wrote the op-ed.
You didn't expect
Oh, that's why
any
she wrote the
house manager in
op-ed. See
Australia
that?
to show up.
She didn't write it though.
He flew
Hold
from
on.
England to testify that Mr.
That's
Depp's
why I
fingertip
wrote
was
the
found
op-ed.
exactly
Oh my
where
God.
his finger from England.
Hear that again?
You
Right,
didn't
watch this,
expect
watch this.
King, the house manager in Australia, to show up from England.
Again. That's why I wrote the op-ed.
That's why I
didn't
wrote the
expect-
op-ed. All right. Now we can go ahead and do this real quick. Right, op-ed. Whatever. But yeah, she's tripping. Let me put this back real quick. She is tripping hard. Put that live. Oh yeah, well, I got something I got for y'all real quick too. Leave me alone. Go back to the YouTube. Gotta go to it. Oh yeah, watch this.
It's been agonizing, painful, and the most humiliating thing I've ever had to go through. I hope no one ever has to go through something like this.
Oh yeah? Everybody but you. That's who we hope.
I just want Johnny to leave me alone.
You want him to leave you
Leave
alone?
me alone.
Yes. That's fair.
I've said that.
He said that's
3
fair.
times now.
I want you to leave me alone, huh?
After
He said, what about this? He said, what about this? What about this? No, I can pull this up.
We can put it in as 3.
I'm not fighting with you. So, which guy, does that seem normal to you? Does that seem normal to you?
I think this is
You
it.
told me tonight that you couldn't imagine your life without me, and now you're throwing your ring on the ground. Does that seem normal?
Let's have you tell me.
That seems sober? You seem normal?
Leave me alone, but begging Johnny to come back.
Does that seem normal to you?
Borderline personality disorder.
I'm borderline.
This man drunk though when he's saying it.
You know, I've been consistent all night saying, don't go, don't fuck this all up. I'm not fighting with you anymore. I've been saying this to you the whole night. I'm really sorry we disagreed. You're not perfect. I said this 2 hours ago.
Yeah, look at her just begging though. Like,
No.
Sort of things in there, 'cause like, otherwise we could.
Oh, no, well, yeah,
Only-
the
only
numbers
she
of talking
can
stay. I just don't want to say
decide
disputed.
when somebody leaves her alone.
I don't
That's-
think any of them say this.
That's nice.
No, the numbers, I tell the jurors
Makes a lot
to
of
disregard
sense.
the numbers and the
Okay.
heading. That's better for the record if we keep it that way.
What is this?
That's why I wrote the op-ed. Is I was speaking to that phenomenon. How many people will come out?
Let's see what else. Yeah, let me press play on that real quick.
AA. So these are only copies.
Yeah, exactly, Lilis. Miss Heard did not write the op-ed herself, the defense says. Amber, I wrote the op-ed. That's why I wrote it. Oh my god, she's so stupid.
This is painful.
Oh my god. Alright. Alright. Alright, I'm gonna jump back on the stream. I'm gonna end it real quick and start up something else. Maybe we'll try to decide what we're gonna watch. Alright, yeah, I'll be right back. Probably I don't know. I'll decide. I'll see it. I'll turn it back on. You'll see the title. We'll see what we're rocking with. Just gotta research and see what we want to do. All right. See you in a sec.